All right, Facebook. This is Brad Bodis with the Bond and Bodis Law Offices, and this is our 10th edition of Facebook Live. Those of you that have checked in before know that we started doing these presentations when we all started staying home a couple months back. Our firm just decided to do these presentations on Facebook as a way to keep people up to speed on what's going on and to just try to address some of the financial concerns that we know a lot of you are having. Today, I am joined by my good friend and law partner, Ed Woods. Ed is the managing attorney for our offices in Mississippi. And in Mississippi, we have offices in Jackson, in Hattiesburg, and in Vicksburg. The Bond and Bodis law offices are located also throughout Alabama and in Knoxville, Tennessee. And one thing I've wanted to make clear through all these presentations is that during this COVID pandemic, we know a lot of people are concerned. We know a lot of you are going without paychecks. Those of you running your own businesses, many of you have been shut down and revenues are down. We are offering absolutely free initial consultations with an experienced attorney, and we're doing them from the comfort of your home or office. At the bottom of the screen, you see our toll-free number, our website address. We have appointment specialists standing by. Call in at any time if you'd like to schedule a free consultation, or feel free to go to our website. We have quite a bit of information on our website. Our attorneys have blogged on just about every topic you might imagine, and we've got a good podcast also. Our website is completely searchable, so if there's a particular issue you want some more information on, go to our website. And then at the website, you can fill out a form there to request a consultation. But whatever you're comfortable with, we're encouraging people to be proactive. Don't wait until things are really behind or you're facing a potential foreclosure or repossession of your automobile. Be proactive now. Reach out, talk to one of us. Just because you call us doesn't mean that you're a candidate for bankruptcy. It means that you're being smart and that you want to explore all your options and you want to get good advice. So with that, this week's topic is to address some of the myths that are out there concerning bankruptcy. I've been practicing bankruptcy law for over 30 years. Our attorneys in the Bond and Bodis law offices have been helping people for over 3 decades. But we know that there are a lot of misconceptions, a lot of just falsehoods about bankruptcy on the internet. So we're going to talk about some of those myths here today. Again, I am joined today by my good friend and law partner, Ed Woods. Ed has practiced law with us for a long, long time. Ed is a fine attorney, fine man. He and his wife, Renita, are good friends. We've known each other's families for some time. And Ed, in addition to practicing law with our firm, has served for a long time as a justice court judge in Mississippi. So he's the go-to guy if you have questions concerning financial matters, bankruptcy issues in the state of Mississippi. And he has a great staff in Mississippi. We have just a wonderful team of both attorneys and other good folks that want to help you with your financial problems. So Ed, welcome to Facebook Live. We appreciate you being with us today.
Thank you very much. I'm very glad to be here.
Ed, why don't you just give a brief overview of your experience and your background for our viewers here today?
Okay. Well, as Brad said, I'm Ed Woods. I'm a licensed active member of the Mississippi Bar. I've been practicing law in Mississippi since 1991. We I've been, I think, privileged and honored for that period of time to be able to help people address their financial problems, solve their financial problems for them, help them get past the problems that folks that are burdened with debt have, and that's the bulk of what we do in our offices here. We pursue abusive debt collectors on behalf of clients to stop that and to get them compensated under the law. We also work with disability clients, VA disability and Social Security disability clients, helping them navigate the choppy waters of those two entities. So that is what we do, and takes up our time mostly.
Well, Ed, as I said earlier, you and I are going to talk today and try to straighten out some of the myths and misunderstandings concerning bankruptcy. We've already had some calls, text messages. You and I are both older guys, so the social media stuff, we're still learning a little bit, but we have some questions coming in, and I want to address some of these.
Okay.
The most important thing for viewers to know is that the bankruptcy laws are designed to give good people a fresh start. Ed, you and I, as we've said, have been both doing this for a long time. And I think the first misperception that I want to set straight is the people that come to see us in our offices, as a rule, are good people who have run into some bad problems. There's this myth out there, there's misperception that somebody that files bankruptcy is a deadbeat or a bad person. I just don't find that. I have to keep, and I know you do too, a box of tissues on the corner of my desk, because people, it's a tough thing.
It is. And I'm not sure where it came from. I know a long time ago when you and I first started doing this, there was a real stigma on people, and people felt like if they were talking to us about their financial problems, that must mean that they're a failure in life, that they've made horrific decisions, that they're somehow a defective human being. And as you know, that is just about as far from the mark as it can possibly be. The old saying, bad things happen to good people, and that is absolutely true. So most of our clients, are people who are hardworking, they're honest, they are stressed because they can't pay their debts. They are worried about it. They're not sleeping at night. It's causing other issues in the family sometimes. And I tell people, listen, this kind of situation could happen to me. It could happen to any of us. This is not about you as a person. This is about a set of circumstances that you are confronted with, largely, outside your control. That we can fix, that we can help, we can address, we can make it better. I have seen that over the years, and I've just, it's distressing to see that, because I don't like to see people like that. I want them to understand we can help them.
And isn't it great once folks do come in and we get over that emotional point, and then we set forth a plan for them as to how they can obtain a fresh start. Isn't it great to see the change in people when they leave our offices?
That is exactly right. It is like you've seen in your office, and I've seen in my office over here. Literally, when you tell people that what you can do to help them, you can see it on their face. You can see it's as though a yoke has been lifted from their shoulders. And yeah, I will tell you, some people say, why do you want to be a bankruptcy lawyer? Well, I tell them, because I can help people. Okay. Far more in this type of practice than maybe any other out there. So not only does it help them, but it's good work for me, because I can help people with what I have.
Just to reiterate what you just said, I get the same question, and I tell people there is no area of the law where you can do more good for a person more quickly than you can with the bankruptcy code. And for those of you that don't understand how bankruptcy works, the instant we file a bankruptcy petition for you, there's an order entered by a federal judge ordering all of your creditors to leave you alone. The collection calls are stopping, the letters stop. You're given a chance to get on with your life and provide for you and your family. Ed, a lot of people, a myth I hear is that when you file bankruptcy, your credit's ruined forever, or you can't do anything for 10 years. What do you tell people about that?
I tell people, because that is a very common myth and a common question. People are worried about the impact. Certainly, bankruptcy filing is going to impact your credit. We know that. And the law says that there's a period of time that the fact you filed for bankruptcy can stay part of your credit file. But what I generally tell people is that that's at the moment that we're facing these severe financial problems, that's a secondary concern, and it's not going to ruin your credit for life. It's not going to ruin your credit for 10 years. By taking control of your financial situation and getting these issues worked out, that in and of itself will lead you down a path to rebuilding your credit and reestablishing your credit. So that is a very common thing, and that's just kind of in a nutshell what I hope people understand when they're talking to me, because it's not going to wreck your credit for your whole life, and it's not going to wreck your credit for the next 10 or 12 years either.
I think a good way to help people understand it is this. First of all, by the time most of our clients come to see us, their credit's already in pretty bad shape. And I like to make the comparison, if I'm a banker and you come to me today and you want to borrow money, and good, you've never filed bankruptcy, but you owe a lot of people money. And if I lend you money today, then next week you could file bankruptcy on me and all those other people. But if you come to see me a week after your bankruptcy discharge, number one, you don't owe anyone else. And number two, if you file this Chapter 7 bankruptcy, you can't file again for another 8 years. So there's a pretty good chance you're going to pay me. And in fact, most of our clients find letters from local car dealerships in the mail shortly after their discharge offering financing, certainly pre-approved credit cards. Now, they're not the best terms, and you've got to start over and begin rebuilding, but it's certainly possible, and it's possible to do it quick. Ed, question here, should married couples, or do married couples need to file bankruptcy together if they file?
That's a great question, too, because we consult with a lot of families. So basically what I'm looking at is when I'm talking to a married couple, I'm trying to determine whether the bulk of the debt issues are coming just from one spouse. Say, for example, maybe this is a recently married couple, and unfortunately one of the spouses has brought some financial baggage in. A lot of times in that case, we don't file a case where both spouses join in. We file it simply for the spouse who is having the greatest difficulty. So the answer to your question, do both spouses have to file? Absolutely not. And that is something that when you're consulting, with a bankruptcy lawyer, that's something that needs to be talked about early on, and the situation needs to be looked at and a determination made at that time. But it is absolutely possible for married people to file just a case for themselves. Now, on the other side of that coin, a lot of times married couples come in here, their financial lives are so intertwined that then in that circumstance, it's going to make sense for both of them to file. They can file one single case, pay one attorney's fee, pay one filing fee, but both of them get the relief that the bankruptcy code allows.
Well, what you've said is exactly true, and one of the important reasons why, if you're considering filing bankruptcy, make sure you meet with a qualified, experienced bankruptcy attorney. Bankruptcy is something that hopefully you're only going to do once in your lifetime. We have occasions where people get into trouble again, but if you're going to do it right. This isn't something you want to price shop on, or just hire whoever has the biggest billboard. You want to perhaps interview a couple of different attorneys and make sure you hire somebody that you feel good about. You meet their staff, you feel good about their staff, how you're treated when you come into the office, how follow-up calls are handled. And again, you want somebody that's going to be there to protect your discharge after you're done with your bankruptcy. So you want an attorney that's going to be around. If a creditor is calling you after you've received your discharge, you may have grounds to sue that creditor, and we're going to help you with that if necessary too, because that federal discharge order you receive, again, is an order by a federal judge telling your creditors to leave you alone.
And Brad, you'd be surprised at the number of people who do get contacts. For anybody listening to us, if you've had a bankruptcy in the past, I've had people tell me they thought, oh, well, since the bankruptcy's over, I thought they could just go back and kind of pick up where they started. So that sometimes is a common misconception. People don't fully understand that when you get a debt discharged in bankruptcy, it is gone forever.
That's right.
Yeah.
That's right. And you need an attorney that's going to protect you with respect to those debts. Yep. Ed, I've been told that you can't do anything with student loans in bankruptcy.
Oh, my goodness.
Tell me about student loans.
Yeah. Okay. So, yes, it is true that if you look up the sections of the bankruptcy code that talk about that, you will find that the code says that you cannot get a discharge or an elimination of that debt. But that does not mean that we can't deal with student loan debts in a bankruptcy case. A lot of times, and of course it depends on the circumstance, but a lot of times an effective strategy for people who have a lot of that type of debt is to look at a Chapter 13 debt consolidation. So we put the student loan in the debt plan like we put every other debt in that debt plan. And for the period of time, usually 5 years, perhaps 3, but usually 5, the person that owes the student loan debt can make some real headway. In some instances, actually pay it off, so that when they get to the end of that case, they don't have that burden. So it is absolutely a myth that you can't do anything with student loan debt in bankruptcy. It is more difficult to deal with than other types of debt, say a credit card debt, and that underscores why you want to talk to an attorney who really knows what he or she is doing. But it is absolutely not true that we can't address student loan debt in bankruptcy. Not true.
Great point. And of course, there are instances, there has to be an undue hardship, some
Right.
sort of hardship that has occurred that's going to make it very, very difficult to repay the student loan. In those instances, we can actually get rid of the student loan in bankruptcy. But there are also administrative options to deal with student loans and perhaps discharge them. And each of our attorneys are up to speed on those administrative type proceedings. Again, call one of us. Let us talk to you about your problems. No obligation. We just want to walk you through what your options are and make sure that you fully understand your rights guaranteed by federal law under the Bankruptcy Code. Just a quick break here to remind people what we're doing. Ed Woods and I are with the Bond and Botus law offices. We have offices throughout Alabama, Mississippi, and in Knoxville, Tennessee. And during the COVID pandemic, we are offering absolutely free initial consultations with an experienced bankruptcy attorney and we are doing the consultations from the comfort of your own home or office. Certainly, if you want to come in and meet with one of us, we'll use appropriate social distancing. Social distancing. Getting used to that now, Ed.
Yeah, really.
But if you want to meet by phone or video, we'll be glad to do that. Whatever you're comfortable with right now, we just want to make sure that you get good advice and you're as well prepared as you can be moving forward. If you'd like to schedule an appointment with one of our attorneys, our toll-free number is on the bottom of your screen. We have appointment specialists standing by that will be glad to talk you through scheduling the appointment and the information you need. Or if you're not quite ready to do that, you're welcome to go to our website, which is also on your screen. We have a wealth of information on our website. It's completely searchable, and there's a form there that you can fill out to request a consultation. Please be proactive. Please reach out for help now. I tell people this regularly. Although I'm a bankruptcy attorney, my first goal when consulting with a new client is to figure out if we can keep a way to stay out of bankruptcy. Bankruptcy is necessary. We're going to do it right. But if there are other options, we're going to address those too. So, Ed, returning to some of these questions, been told that there's now something called a means test in bankruptcy, and it's really difficult to get a bankruptcy approved. Is that true?
Absolutely not. It is certainly true that there is a means test in bankruptcy, and we could have a whole day of a discussion about that. So I won't bog us down on that point. But basically, all it means is that in preparing to file your bankruptcy, we look at your income and expenses, and we have to compare your income and expenses to some, I hate to use the word standard because that's really not true. But anyway, let's just go with that. So a kind of a standard. These standards came from the Internal Revenue Code that we have to go by. But the bottom line is this. There is absolutely no reason for a person who is facing a debt crisis to worry about the means test. That's what I do. Okay. That's what I will do, or you will do in your office. And I don't recall a time where I ever had to look at somebody and say, you know what, I know you're in such a financial problem here, but there's this thing called the means test is just an insurmountable obstacle, and I'm sorry, and I hope you have a nice life and see you later. No. That is not how it works. We do have to abide by the means test, but there are certainly ways to properly do that. And a person who is, an honest person who is confronted with debt problems is just not going to. We're not going to let the means test stand in your way.
Bankruptcy is by no means a simple process. You can do it on your own. I wouldn't advise you to do it on your own. In fact, one of our attorneys recently blogged on this very issue, and you'll find it on the blog on our website at bondandbodus.com. But if you hire an experienced attorney, and Ed and I have been doing this, and the attorneys in the Bond and Bodus offices for decades, we'll make sure that your bankruptcy is filed correctly. And we'll make it as painless for you as possible. We have procedures in place and practices to gather the necessary information and to help you get your bankruptcy filed properly. Again, bankruptcy is something you want to make sure you do right. We often get calls, people kind of price shopping, want to know what we charge for a bankruptcy. Well, we're not going to tell you over the phone what we charge. That's why we offer a free initial consultation. We don't treat our clients like a commodity. We want to talk to you. We want to evaluate your situation. And then, and only then, will we quote you a fee which we think is fair to you. I can tell you we're not going to be the cheapest, but we're not going to be the most expensive either. We're going to quote you a fair fee for your situation. I can also tell you this: it is a whole lot cheaper to pay to have a bankruptcy filed correctly than it is to pay to fix a bankruptcy that was filed incorrectly.
Brad, a lady came in to see me a number of years ago, and I felt so badly for her. She was an intelligent lady, articulate lady, and she had tried to file her bankruptcy case on her own, and it was just a jumbled mess. And I ended up helping the lady, but I just filed a motion to dismiss the case because it was just so jumbled up that it what you said earlier about please talk to a competent, experienced attorney. It just if nothing else, do that, because this lady ended up paying my fees, probably twice what if she would have come in and we would have gotten it done correctly. She could have gotten the relief that she needed and wouldn't have had to gone through the stress and strain and extra cost. So I hope people understand that.
And I should just to add to what you just said, in that particular situation, you moved for the court to dismiss her bankruptcy so that you can refile.
Yep.
Folks need to know that when a bankruptcy is filed, a Chapter 7 straight bankruptcy, you do not have an absolute right to dismiss that bankruptcy. There are instances, plenty of them, where people have filed on their own and misunderstood the rules pertaining to exemptions or the means test or something else that's pretty darn important. And they were unable to dismiss that bankruptcy. So again, you want to make sure that it's done right in the first place. Ed, I mentioned Chapter 7, and we've used the term Chapter 13. Can you just give our viewers a quick overview of the difference between a Chapter 7 straight bankruptcy and a Chapter 13, which I think is more akin to kind of a corporation doing a reorganization? But give us your perspective.
And that's right. On Chapter 13, I've been known to tell people that Chapter 13 is kind of like the kid brother to Chapter 11, which is the big commercial chapter. But yeah, so the basic differences are this. So what we call a straight, when a person hears bankruptcy, they probably are thinking about Chapter 7, a straight bankruptcy, where the idea is that you're going to eliminate all of the debts you possibly can eliminate because you can't pay them anyway. Okay, you demonstrate to the court that you cannot possibly pay all of these debts, and the debts are, with certain exceptions, eliminated. So there's no plan, there's no attempt to repay debt. You just, if you get a discharge of the debts that the law allows, in your circumstance, when you can essentially show that you can't pay your debts. Okay, so that's Chapter 7. Chapter 13 is where we're going to sit down with a client and say, okay, you've got a pretty good income stream here. You do have some ability to repay some of your debt. So we're going to put together a plan called a Chapter 13 plan. And in that plan, we are going to provide for the payment of your debts. Now, in crafting that plan, we're going to also have to take into account what your household income is. So that tells us how many dollars we have. And secondly, we understand that you've got to pay your light bill. You've got to pay your utilities. You've got to be able to buy groceries at the grocery store. So you're going to have living expenses that have nothing to do with the debts you owe, but that claim a chunk of the income that comes in. And then the amount that's left over we call disposable income, and that's generally the income that we're going to work with and put into your plan, and hopefully and let that income pay as much of your debt as we can. And then at the end of that plan, usually 5 years, but sometimes 3, whatever you haven't been able to pay is forgiven. It's discharged. So that's a admittedly oversimplified answer to your question, but that's kind of the general idea and the general difference between Chapter 7 straight bankruptcy and Chapter 13 debt consolidation. And there are other reasons why you definitely want to choose one or the other. We see a lot of folks with mortgage problems and things like that, and almost always your Chapter 13 debt consolidation is going to be the way to go with that. But again, that's something that you need to be talking with an attorney about, getting some tailored advice to your situation to make sure you are making the right decision.
Ed, that's a great segue into this next question here, because the next question is, will I lose my house? Will I lose my car if I file bankruptcy? So I can say, after having done this for over 30 years, and Ed, I'm sure you can say the same thing, that I have never, ever had somebody lose their home or lose their car through a bankruptcy when that was not what they intended to do. So there are instances somebody has a home they just can't afford, and they file a bankruptcy and they abandon and surrender their home.
Right.
But if you do want to keep your home, we can almost always craft a way for you to do it. So one of the reasons you may want to file a Chapter 13 as opposed to a straight bankruptcy, for instance, is if you're behind on your mortgage and you need a method to catch up the payments that you're behind on. We can file a bankruptcy up to the very eve of a foreclosure, stop the foreclosure, give you a chance to catch up on those payments and keep your home. Same with a car, up to the eve of the repossession. Now, don't wait, please, until the day before the foreclosure or repossession before you call us. The more time you have, the more time we have, the better job we're going to be able to do. And then there's another situation, and I don't want to get too deep in the woods here, but you're allowed to keep a certain amount of property when you file bankruptcy. And although bankruptcy is a federal law, each state sets the amount of property you're able to keep. They're called exemptions, and exemptions change. For instance, in Mississippi, where Ed practices regularly, you're able to preserve up to $75,000 of equity in your home.
Right.
Whereas in Alabama, the number's a lot smaller. It's $15,500 worth of equity, or twice that for a married couple, or $31,000. And in Tennessee and in other states, the numbers are different yet again. But if you have more property than you're allowed to keep when you file bankruptcy, we can then craft one of the Chapter 13 reorganization plans that Ed discussed and allow for you to keep that property, because you will be paying your creditors as much as they would get if you did liquidate. So again, all the more reason to talk to an experienced bankruptcy attorney, get good advice before you select an attorney. Interview that attorney. Make sure he or she is somebody that you feel comfortable with. I want to add one more time, during this COVID pandemic, we are offering absolutely free initial consultations with an attorney. You can call the number you see on your screen or go to our website. We will set up a phone or video consultation if you're more comfortable with that, so that you can do it from the safety of your home or office. Or if you want to come in and meet with one of us, we'll do it with appropriate social distancing and making sure everyone's safe. Courts in both Mississippi, Alabama, and Tennessee are handling court hearings by telephone now. Everything's filed electronically, so the process is seamless and safe for you if you decide that you do need bankruptcy assistance. But reach out. We'll be glad to talk to you. No obligation. This is our 10th Facebook Live episode. Last week, we had a mortgage specialist, and we talked about mortgages and financial challenges due to bankruptcy and divorce. That Facebook Live episode and all of our previous episodes are available on our Facebook pages. You can go and watch them at any time. And if you know of somebody that you think may benefit from this presentation, please let them know. This video will be available on our Facebook page, and folks can go back and watch it later. if they have questions, and then follow up with a phone call or a visit to our website. Ed, I do want to return. We have a couple of questions here that we haven't addressed. So this person says, will I lose my job? Will it be difficult to get a job if I file bankruptcy? What's your experience there?
Wow, very common question. I will tell you that 98% of our clients are employed people, maybe more. And you absolutely will not lose your job simply because you file a bankruptcy case. In fact, there is a provision in the bankruptcy code that is aimed at preventing that type of discrimination against a person who is, responsible, honest person who is just simply trying to get their debt situation under control. And I can tell you, in my experience of almost 30 years, I don't recall ever getting a phone call from a client saying, hey, I just got fired because my employer found out I filed a bankruptcy case. It just doesn't happen. It just does not happen. It's just such a non-issue. I'm sitting here kind of struggling, trying to think if I've ever had any. It just doesn't happen.
Ed, I like to add in here, and you pointed out correctly, there are provisions in the bankruptcy code that provide that you can't be discriminated against because you've sought bankruptcy protection. Now, we probably have a lot of African American friends that are watching, perhaps females, perhaps older individuals that know that they're protected by anti-discrimination laws, and it still goes on. We know that. But here's the practical matter. In addition to you and I both being bankruptcy attorneys, we also are employers. We have people that work with us in our offices and help us to take care of our clients. As an employer, I would much rather have somebody working with me that has addressed their financial concerns, that has things under control, rather than somebody that's worried about how they're going to pay their bills, that may be getting calls from collectors. The anxiety somebody deals with when they can't pay their bills is tough. It keeps people from being a good employee, keeps people from being a good spouse, a good father, a good mother. I would much rather have somebody working with me in my office that has sought bankruptcy protection than somebody worrying about bills.
That's a great point, because for people who are facing financial problems and difficulties, I would suggest and argue that it's probably the responsible thing to do. People think that, if you file bankruptcy, you're bad, and we talked about that earlier. But when you are facing a situation that is overwhelming you and you do not have the ability to pay your debts, I would argue that it's the responsible thing to do. Just like you're saying, once you get that stuff off your back, you can go to work, to your job, and concentrate on doing your job that you're getting paid for, and know that when you get back home, your car is not going to be hooked up to a tow truck. So, and I tell people that. I make no bones about saying that.
So we've so far established that people that file bankruptcy aren't bad people. Most of the people, the vast majority of people we see, are good, hardworking people.
That's right.
We've established that your credit's not going to be ruined forever. In fact, for a lot of people, their credit score will increase almost immediately after their bankruptcy filing. We've established that you're not going to lose your home or your car or your job if you don't want to lose your home or your car,
right,
or your job.
Right.
If you want to keep your job, you're most likely going to be a much better employee after your bankruptcy discharge. Ed, if I am renting, is my landlord affected by my bankruptcy? Am I going to lose my apartment or the home I'm renting if I file bankruptcy?
That's a great question. And the first thing I would say is, in that situation, time is of the essence. get some help now, because it basically goes like this. So if you're behind on your rent, but your landlord has not secured a court order evicting you from the premises, and you come in and see a competent bankruptcy attorney, then almost certainly we're going to be able to use what's called the automatic stay to prevent you from being evicted. Now, if you're coming in to see a competent bankruptcy attorney and you have been properly served with an eviction notice in your state, it's gone to some sort of proceeding, and a judge has entered an order that says you're evicted, you're in a much worse position. So that's why I say the answer to this question is kind of yes and no, depending on what's going on. So if you're behind on your rent and you think your landlord is about to come after you and you don't see anything else, get in to see a competent, reputable bankruptcy attorney quickly so that action can be taken to protect you.
And this is similar to a foreclosure. The
Yes.
sooner you get to an attorney and get advice, the better. And the timing of a bankruptcy filing is important. Say you come to us and you've got some money, but you're behind on your credit card bills, you're behind on your rent payment or your mortgage payment. We're going to tell you which bills it might be good to catch up on before you file bankruptcy. We're going to tell you how to prioritize your bills. That's part of our job. And again, perhaps even prevent having to file bankruptcy. But if you do file, the timing is very important. Again, if you're in a bond and bonus law office, you're not a commodity. You're not somebody that is just, a $500 bankruptcy filing or whatever the number may be. You're a person with unique needs, and we're going to help you address your needs in the best way possible. Ed, what if my wages are being garnished? What can be done about a wage garnishment with bankruptcy?
Wage garnishment can absolutely be stopped. As a matter of fact, we see that maybe daily or something very close to daily, where an employed person has gotten a garnishment. And when you file a bankruptcy case, it doesn't matter whether it's Chapter 7 or Chapter 13. In almost every instance, there is an automatic stay, a court order that comes into play automatically. You don't go testify before the judge. You don't go to court. It automatically comes into effect, and it automatically voids that pending garnishment. It doesn't matter whether the garnishment, your employer has just gotten it and said, "Hey, listen, I got this garnishment," or it doesn't matter if the garnishment has already begun. Now, if the garnishment's already begun, we're going to be limited in what we can do about the past garnished amounts, but we can certainly stop the garnishment amounts going forward. So bankruptcy can be a very effective way, a very effective tool to deal with a garnishment. Again, if you can't pay it, and obviously if people could pay it, it probably wouldn't have been a garnishment to begin with, and we would never see that individual. But bankruptcy is a very effective way to deal with a garnishment.
Again, next question gives me a great way to transition from the answer you just made. And the question is, what if I'm being sued by a creditor? Can you stop the lawsuit? Well, I'm going to address this one. A garnishment, which Ed just addressed, is the result in most cases of having been sued and lost the lawsuit. So in order for a creditor to garnish your wages or garnish your bank account, they first have to sue you and win the lawsuit. They have to have a judgment against you. The garnishment is a way of collecting on that judgment. Yes, if you are being sued, we can stop the lawsuit dead in its tracks. The automatic stay will stop just about any type of legal proceedings. There are some exceptions for marital type, child support, those type things. But even then, usually we can at least pause the proceedings and give you a chance to catch your breath and come up with a plan. If you're being sued by a credit card company or a loan company or a former landlord, someone like that, maybe a car that was repossessed in the past, we can stop the lawsuit in almost all cases. But get to us while there's time.
Yes.
Ed, I know in Alabama, if you're sued in a small claims type court, you typically have 14 days after you're served with the lawsuit to respond. How do those rules work in Mississippi?
In Mississippi, it's 5 days. Okay, 5 days. So, you know, our small claims court or justice courts, that's where I've served for a number of years in my hometown. And in Mississippi, now this is going to change from state to state. But in Mississippi, the justice courts, the small claims courts, have authority up to the amount of $3,500 in a debt collection or other type, in any situation where the law allows an award of damages. In Mississippi, $3,500 is that limit, and if they need to go more than $3,500, they have to go to a different court. But to get back to your question, the point of it is yes, in small claims court in Mississippi and obviously in Alabama, when you're sued and you get notice of that lawsuit, you probably only have some days to deal with it. And that would be a great time to sit down with a bankruptcy attorney. Like you said before, it may be that this is just a one-time thing that we might be able to address outside of a bankruptcy. I'm not saying you run to the bankruptcy court. I'm saying you get advice. And if this is just another problem in a long string of financial problems, yeah, probably we're going to be talking about a bankruptcy. But if not, there may be answers, there may be other things, non-bankruptcy things we can do to deal effectively, just as effectively with that particular situation than if we went through with a bankruptcy case.
Right. And I want to make it clear, because sometimes we take these things for granted. When you're served with that lawsuit, the time is running. And if you do not respond to that lawsuit properly, that doesn't mean calling the attorney that's suing you. That doesn't mean sending a letter to the attorney. If you don't respond properly, then the court can award a judgment against you by default. And that's what starts the garnishment or other collection, perfection of that garnishment. I'm sure you've heard it too, Ed. I tell people, well, you're being garnished because you lost a lawsuit. And they say, well, I never went to court. Yeah, you don't. That's the problem. You didn't go to court.
Right.
So if you're served with those papers, come in and see one of us just as quickly as possible, or call us and we'll do the consultation over phone or video.
Yeah.
Ed, I'm going to play back to, I answered this question earlier indirectly, but let's just ask it head on. How much does it cost to file bankruptcy?
Well, I generally ask people, how much is it going to cost not to file bankruptcy?
Yeah, good answer.
Because, yes, we are private law firms, so we charge attorneys' fees. And it's a little different in 7 or 13. Another thing I tell people, because this is a common thing, they're just calling around or saying, hey, how much is it going to cost me to do this? I never really answer that question directly outside of a consultation, because first of all, I don't know whether you need to file bankruptcy. I don't know if you do need to file bankruptcy. What type of bankruptcy do you need to file? What is going on? I need to know what's going on before I can intelligently and fairly discuss with the client. In Mississippi, on our debt consolidations, like you guys, I think you have them there in Alabama too. We have what the judges call a no-look fee. So that's a preset fee that the judges tell us what we're going to charge. It's not us telling the client or negotiating with the client. It's a set amount. And we generally pay that off through the debt plan anyway, so the client doesn't have to come up with anything anyway. No attorney's fees up front. On the Chapter 7 side, there's no fee. I mean, there's no plan. So that's just going to kind of be a sliding scale. It's not most people think, we're going to charge them $10,000 or something. No. I would rather have the free consultation, get the person in, look at it, and then make that decision. But it's not going to be nearly what you think it is.
Go ahead. I didn't mean to cut you off.
I was just saying, most people have this conception that we're all, charging them these exorbitant fees. And I'm sure lawyers in other areas of not consumer bankruptcy practice might be charging them $1,600 an hour. But that isn't how it works here. I understand that people come see me are already financially strapped. So I'm going to bend over backwards to get them the relief they need for what they can afford. That's fair on both sides of that. And that's probably the best way I can answer that question.
I do want to address, first of all, we know you've come to see us because of money problems. The last thing we're going to do is make your money problems worse.
Right.
We're going to look at your situation and we're going to come up with a plan. If you need to file a straight Chapter 7 bankruptcy, then yes, in most instances, your attorney fee needs to be paid before the petition is filed, but we can work out payment arrangements. We can set up a plan. If you do a Chapter 13 bankruptcy, then in all of our offices, the great bulk, if not all of your attorney's fee, is going to be paid as part of your plan of reorganization. You're going to pay very little money, if any money, up front to get your bankruptcy filed. There is a no-look fee in most bankruptcy courts. To be clear, the no-look fee is not the court telling us, or at least in Alabama, it's not the court telling us what we can charge. It's a maximum amount we can charge without setting forth particular circumstances that would merit a higher fee. But the no-look fee is a guideline set by the court, and it's going to be pretty uniform for any bankruptcy attorney. But here's the great part. Here's the great part about that no-look fee in Chapter 13. In most of the Chapter 13 bankruptcies that we file, it's not our client that's paying the fee. It's the creditors that are paying the fee. And the way that works is this. As part of the plan we're putting together, we determine how much money you have available. If we take your average income and we deduct your reasonable and necessary expenses, we determine what amount of money is left over. And we fund your plan with that payment. So if MasterCard and Visa and American Express are owed $10,000 or $20,000 or $30,000, we're not necessarily paying them that amount of money. We're paying them whatever percentage is left over after the attorney's fee, the court costs, the trustees' commissions are paid. So I like to tell people, we're forcing your credit card companies essentially to pay your attorney's fee when you do a Chapter 13 bankruptcy. At least if your bankruptcy is done right by a qualified attorney, that's what's going to happen. Wouldn't you agree, Ed?
I would agree wholeheartedly.
We're close to an hour here, and I don't want to go too long with this presentation. I want to remind folks that we are here to help. We know these are stressful times. We know you're dealing with a lot of anxiety. It's best to talk and get the best advice you can. A lot of people avoid bankruptcy and avoid bankruptcy attorneys like the plague. We know that we're the last person you want to see. And there are a lot of fixes that you'll hear out there on radio and on television, ways to avoid bankruptcy. Well, it may be good to avoid bankruptcy, but in all instances, it's not. And you need to know what your options are. The bankruptcy laws are set forth by our federal government to protect you, to protect an honest debtor, to give you a chance to start over. It can often be the first step in rebuilding your credit. Seek the advice of a qualified, competent attorney. I can speak for each of our attorneys. They take what they do very seriously. Many of us look at this as almost a ministry because we know people are hurt and they're broken when they come to see us often. It's tough owing money. We're going to sit down, and we're going to talk you over the phone or by video or Zoom or whatever works for you, and we're going to address your needs, and we're going to come up with a plan for you. Call the number on your screen, go to our website, whatever works for you. We'll set up an initial consultation with an attorney at no cost to you. I want to remind you that we're going to continue to do these Facebook Live presentations every Wednesday at 1:00 p.m. Central Standard Time. And these presentations that we've done over the last 9 weeks, this being the 10th week, are available on our Facebook pages if you want to go back and watch them later. We're trying to cover information that is important to you right now. I can tell you we're going to have a very interesting show next week. We're going to have a gentleman that's actually been through the bankruptcy process himself and has successfully rebuilt his career and written a book about it. So I look forward to that, and I want our viewers to be able to see what life is like on the other side of bankruptcy. Ed, do you have any words you want to say in closing before we sign off today?
I would just say this, Brad, to anybody who is watching this now or to anybody who might watch it later. If you or you and your family are feeling the stress and pressure of debt, please don't feel like you're alone. Please don't feel like there's no way out. There is. We've been talking about some of this today, but there is. So reach out to somebody. Don't let fees or means tests or all these things we've been talking about get in your way. Reach out to a competent individual. Consult with them. The good ones will give you a free consultation and figure out what you're going to do. Don't suffer in silence. That's what I would say.
Don't allow these collectors to bully you. That they call at all hours of the day and night. They're persistent. You don't need to put up with that. Don't be bullied. Stand up for yourself. Hire, retain a competent attorney to look out for your interests. At the Bond & Bodas Law Offices, we care about you. We want to help you get a fresh start. We want you to be able to put these financial challenges behind you so that you can once again be good, productive members of society, good people to work with, good spouses, good parents. We want to help you be the best person you can be, and we're here to help you in any way that we can. So until next week, Wednesday of next week at 1:00 p.m. Central Standard Time, on behalf of Ed Woods, on behalf of myself, Brad Bodas, and all of the folks in our Bond & Bodas Law Offices, good luck, God bless, and we'll see you again soon. Thanks for joining us. Thanks, Ed.
Thank you.